Welcome, everyone. Thank you for joining us this evening. Um, Welcome to the Media Innovation Center. We are an entity within the Aga Khan University where we deal with incubation and acceleration of media startups. And we host them within for 12 months, where we provide trainings, capacity building, and on top of it all, we provide a $10,000 grant and also a $100,000 stipend for the 12 months. And throughout the 12 months, they'll undergo training, coaching with various experts within the industry that will help them build capacity for the media startup. So by the time they're graduating, they're able to actually stand on their own and continue growing the startup. We have so far incubated and accelerated 5 startups. And currently, we are accelerating and incubating 9 media startups from Kenya, Uganda, and Tanzania. You can watch their stories and you can introduce to them on our YouTube channel and our series Meet the Cohort, where you learn more about the startups, what they do, their team members, and what they aim to achieve during the Innovators in Residence program. So today we are gathered here not in holy matrimony, but to discuss and have a discussion on one of the biggest topic personally for me is the law. The complexity of it is not as easy as people might see. And personally, I am not able to sometimes understand some of these things. And given that we are dealing with media startups, we saw it a crucial and important topic to have, especially with guys who are trying to register their startups. As they begin their journey, they also need to understand that they're all within a law. They are governed by a law, they're governed by confinements of that law. And for them to be able to better operate, they're able to understand what the law is, what it says, what are the boundaries, what can you cross, what can you not say, and above all, how do you protect your content? So today we are joined by one of our trainers. Her name is Liz Lenjo. Let her introduce herself as she introduces the topic of the day. Liz, karibu.
Hi, everyone. My name is Liz Lenjo. I'm an advocate of the High Court of Kenya. I practice under the name and style of my IP Legal Studio, and we specialize in intellectual property, entertainment, media, fashion, and technology law. So I think today we're just going to be having a chill conversation about business law, media law, and intellectual property law, and how to create sustainable businesses in the media space. I think we have been observing a lot in terms of the kind of trends that are there in Kenya and around the world in terms of media businesses. And the fact that we have the internet, it's very easy to start your own media business, right? However, there are so many things that we take for granted, especially around the law. So today we're going to be having some of those conversations just to put things in perspective, so that then should you want to start a business in the media space, you do it from a point of information, a point of knowledge, and you also save yourself some time and, even heartache, right? So first things first, before we get into it, allow us to issue a disclaimer that this information and the content today is purely for edutainment or infotainment. So please do not interpret it as legal advice. At the end of this session, you learn something new or realize that you need something in your business, please seek legal counsel. Thank you.
Thank you so much, Liz. So given that we have 3 main topics, that is business law, media law, and IP law, and even through our engagements, I got to understand that these 3 things are very different and not the same. So probably as we begin this discussion, you could just quickly give us a breakdown of the 3 different laws that we're going to discuss tonight.
All right. So when we're talking about starting a business, there are different aspects of it that one needs to be very aware of. So you'll find that today's discussion is centered around the media law businesses. So if we were talking about maybe another business, maybe say, retail, for example, then maybe we'd be talking about business law where the law starts, and then maybe consumer protection law because now you're dealing with consumers, and then some aspects of intellectual property because you're creating a brand. So in perspective to today's conversation, a business will start from its registration. The registration of a business is governed by business law, which is the umbrella that covers now all these other types of laws within business law. And with business law, the first thing you need to understand is your goals as a business. What do you want to do? Do you want to be a not-for-profit? Do you want to be a sole trader? Do you want to have a company? Do you want to work as a partnership with some of your friends or colleagues, or just strategic people that you know of? So business law helps you identify the right registration that you need to register. It helps you identify also the kind of now tax implications that would be attached to your business as well. And at the same time, also business law will help you understand how you structure your business, how you deal with the different relationships that you have. So within business law, we'd also talk about contract law, the kind of contracts that are important in your business. If you're going to have employees, you need employer contracts, employer-employee contracts. If you're going to, have suppliers, you need some supplier agreements. You're going to need some service level agreements, depending on the kind of engagement also you may have with different professionals or services or service providers. We're talking about even just how the business partners or the people in this space who want to do a business together, how do they interact with themselves? What kind of documents would you need? So, for example, if it's a company, do you need memorandum and articles of association? Because we recently amended our Companies Act. So it's not like before how you'd need a lawyer to draft all the articles and a memorandum of association. There's now already what you can adopt under the system. And then should you choose to have your own, then you can have your own articles and memorandum of association. So they're not a must, but it will depend on the nature of your business. For example, you're going to be a sole trader and register a sole proprietorship. What does that mean for you? Do you know that it can be a dangerous registration regime to have? Because at the end of the day, you as a sole proprietor, you and the business are the same. So if tomorrow there is the problem or you go into bankruptcy, your property is the business's property or the business's property is your property. You know what I mean? So you and the company are what we in law call jointly and severally liable, that you cannot be detached. And you see in business, that's a very dangerous thing. So those are some of the things that you need to be aware of when you're starting a business. Then now in the media context, after you've registered your business, so how are you going to run your business in terms of what kind of regulations are there in terms of having a media business? The media is predominantly centered around the freedom of expression, access to information. So with these two rights specifically provided under the Constitution, again, it's important that you understand how they coexist in the system or rather in the legal system, because there are all these other rights that also exist around us. And how do you then realize how you're going to protect run your business? So with freedom of expression, it's not unlimited. It is limited because it must respect other related rights or other rights around the system. So for example, in the media industry, some of these quote-unquote related rights would be the right of reputation. You have the right to actually ensure that you protect other people's reputation as you're disseminating information. You have the right to you have to respect the right of people's image. For example, you're going to use my picture in your blog. Have you gotten my consent? Things like that. There's the issue of even how you report your articles, how you do your articles, for example. So, the kind of tone that can be tolerated and the kind of tone that can get you in trouble. So media law helps you understand that, because once you're aware of what provisions are there under media law, what say, for example, you wanted to start like a political blog. With political blogs, remember, there's the issues of national cohesion, making sure that your reporting is not propelling hate speech, for example. That there are limitations to the kind of information that you can publish because, again, there's government secrecy. There's kind of information that is considered sacred so that government can protect its people, So with that kind of information, are you able to decide what kind of media business do I want to be? What kind of liability or quote unquote drama can be attached to my style of doing my business so that then I know how to protect myself? And then there's intellectual property law, which deals with it's basically the art of converting ideas into assets, which means that you have this fabulous idea. I have an idea. I'm going to put together a media business. I'm going to give it a certain name. Intellectual property will be able to help you now protect this name into a brand through trademarks. There's a way, maybe you want to write a book, for example. You're able to make sure that once you have written down the book, you protect yourself by registering copyright. You have the copyright. How do you deal with publishers, for example? How do you deal with any distributors if you're self-published? How do you make sure that you gain commercially from this intellectual property that you've created? So I think one thing that's always important to understand is that with intellectual property, it depends on the nature of these ideas that you have, how you express them, and then the law can assist. So we don't patent ideas. People like to use that word, oh, I'm going to patent an idea. No, we're not patenting ideas. We're protecting the expression of these ideas. And in IP law, we have industrial property and we have copyright. It's divided into those two. So industrial property is a bit on the technical side. Industrial property deals with patents. Patents are the highest form of protection in intellectual property law because you get exclusivity around the whole world because its threshold is very high. It is novel. It is new. So novelty and newness basically means that it's never been seen before, never been witnessed before, right? So already that threshold is really high in the world, right? And then in the Kenyan context, it has to be industrially applicable. So it has a very scientific element to it, very technical element. So you find that even when you're trying to claim that you have a patent, we use very scientific language to demonstrate what you have created, how it is novel, how it's different. So, after this talk, perhaps just go online and just check the kind of language they used back in the, I don't know which age. Like in the US, they look at just usefulness when they're registering a patent. So many years ago, they had a patent to a peanut butter and jelly sandwich. If you go online on Google patents and you just search for that and just look at the language, like it's very technical. Like someone will be like a quarter of something, like what? The language is crazy. So already patenting, you'll find in the creative industry, the media space might not be the thing that you want to register, for example. So unless now you have a technical partner, maybe they're good with cameras, they're good with wiring, and they'll create some gadgets that can, change the media space, for example. So then they'd be likely to be eligible for a patent. And then we have what we call utility models. Americans like to call them petty patents. So this is basically an improvement to a patent. A patent gives you exclusive rights for 20 years, which means no one can touch your technology or your innovation without your permission until 20 years have expired or lapsed. And then it falls into what we call the public domain. With that, then it means that anyone now can use it without your consent. So with petty patents, it would be for 10 years. However, now if I'm going to improve an already existing patent, I can do that, but I cannot make money or commercialize from it unless I have a license or permission from the patent holder whose rights still exist. Yeah. So that's very important to be aware of, unless now it already had fallen into the public domain, and then you can register a petty patent or a utility model without needing anyone's permission. And then we have industrial designs in the media industry can be very useful because they deal with the aesthetics, the beauty of things that are created. It might be the colors, combination of lines and shapes, the textures. So in the media space, we're talking about set design, for example. If you look at some of these amazing programs like The Voice, how they set it up, how that spinning chair that they have, that is an industrial design, can be protected under an industrial design. If you look at Idols, the way they have set up their space, their set, the stage, it's also registered under industrial designs. And any other gadgets that just are so beautiful and you feel like they're unique, that would be eligible for industrial design protection. And they are protected up to 15 years. Then finally, we have trademarks, which protect the brands that we create. So this can be the name, the logo, the slogan, the use of lines, numbers, or whatever it is that you put together to create a brand. Now, the thing with trademarks is that it cannot be descriptive of what you do. So, for example, having, I don't know, let me say Liz Media House, for example, I'm not eligible for a trademark because if I'm in the media business, I've already used the word media. I've described my business. So then I'm not eligible. Yeah. So again, it's about very unique use of words, either in ordinary language or in your mother tongue, to brand your goods. Then that way you get, you're eligible for a trademark. So it cannot be descriptive. It has to be unique and creatively used, so that then you get that, you get to claim a trademark of it. Trademarks are renewed every 10 years. So it's always important that you also have that, because how are you distinguished in the market? It's through the brands that we create. So again, trademarks are taken really for granted, but they're very useful. It's how people remember you, your product, or your service. So it's really important. So that is industrial property. And then finally, we have copyright, which now technically protects the expression of ideas. And this cuts across literary works, audiovisual works, specifically literary and audiovisual works, because media, and also artistic works and photography, because that would affect that. Of course, then there's architecture, sculpture, paintings, drawings, musical works, software. These are the bunch of works that are protected by copyright. And copyright can be very technical, as much as people think it's very easy. And we could talk about this for like forever. But with copyright, the different types of copyright works last for a different period of time. Oh, and I forgot to also mention broadcasts are also protected by copyright. So each of these works will be protected differently. So literary works, artistic works, software will be protected for the life of the author plus 50 years after death. Sound recordings, which also I forgot to mention, would be 50 years from the date they were first published. Photographs, the same thing, 50 years from the date they were published. Audiovisual works, the same thing. Broadcast is only protected once it's been broadcasted. So if you did a quote unquote a broadcast and then you put the tape, in your desk, it's not eligible for copyright until it's aired on TV or online for it to be eligible for protection. So generally that's IP in a nutshell. And you'll find that it's not a one size fits all. It depends on your business, on your strategy, and the kind of things that you would like to achieve generally as a business or with your intellectual property.
Wow, that's a lot to take in, and I'm sure that's where most of the questions will come in, given the circumstances we've seen with content creators around the country and how the IPs, their photos, their videos are stolen and are not credited. But before then, I think let's talk a bit about business law, and and I think people always say registration might be the same, because when you register a business, it's the normal KRA government processes. You need to register, type in here and there. But is it different to register a media startup as it from the normal businesses, like say hardware? And probably, are there any special steps, and do they have like a special registration process?
So the thing with business registrations is it entirely depends on your business strategy and your goals. So for example, as a media house, or as a media business, I can decide to be a not-for-profit, right? As a not-for-profit, I have the following options. I can register as an NGO under the NGO Coordination Act. I can register even as a what's it called? A CBO, a community-based organization. I can register as a company limited by guarantee, which is one of the a more complex registration, but still can suffice. I can register a trust or a foundation. That's just not for profit. If I want to be for business, I can register a sole proprietorship. It can be available to you. You can register a partnership if you have a friend or two or more. With partnerships, you have two types of partnerships. You have a general partnership and you have a limited liability partnership. And then we have a limited company, which is also another form of registration. So you can see all these different registrations have this different usefulness. It will just depend on your goals. So that's why this process, we always recommend you have a lawyer, because a lawyer will ask you all these questions and tell you, okay, option A is not possible or is not a good fit for you because of X, Y, and Z. Again, with these different registrations, they will attract different taxation obligations as well, right? So it's always important that you seek legal counsel at the beginning so that you know what is going on, you know what kind of vehicle that you're registering. And you find that it's always good while you're still in the exploring stage to seek this legal counsel, because at least you're able to get the information and then go back home or wherever and re-strategize and rethink your options. And then now when you're approaching now a lawyer to assist with the registration, it's now from a point of observation. You're able, of information and processing. You're able to say, oh, okay, I thought I wanted a sole proprietorship, but I think I might want a company because, you've been informed that we have a new amendment under the Companies Act that allows us to register a company as a sole director. So you'll be like, okay, maybe I want to register a company as a sole director because as a company, I'm separate from the business. We are not the same, one and the same, like a sole proprietorship, for example. So you'll find that all these things are really interrogated by a lawyer so that you're able to find the proper solution.
Interesting. And even as they register, and I'm sure, I think because even in the normal businesses, you find that the number of employees always differ. So if I'm going to register my media startup and I'm saying 5 to 10 or 15 to 30, does that mean there's a difference in financial obligations?
Of course, when you have employees, if you're going to have employees, you will now automatically, as you're registering, you will, as you're declaring online, because we have the eCitizen platform, you're able to do it through the eCitizen platform, you'll automatically be registered for pay as you earn, because now you start paying salaries and you have to remit the PAYE, among other now tax obligations that you likely have. So again, when it comes to the tax conversation, it's not even a lawyer you should be talking about. You're supposed to be talking to a tax accountant or an auditor who is registered and recognized under the Accountants Act. I think the one thing that as businesses, as startups, as business owners, we usually really take for granted is that accounting is a profession as well, very regulated, and it's very easy to also engage a quack. So you want one who's registered, who is acknowledged by the professional body, ISPAC, and you get the proper and legitimate information. Otherwise, you get yourself, in a lot of trouble. So when it comes to these tax issues, please have also a tax consultant or tax advice. So once you've seen a lawyer, go see a tax consultant or an accountant, and you're able to find out, okay, I have this following information. What does my tax obligation look like if I was to register A, B, C, and D? Then you're able to go and sit down and strategize, because also with the accountants, they will be able to help give you some quote unquote trade secrets in terms of, okay, while you're working towards X, this is what you can do in the interim so that you don't either find yourself accruing a lot of tax, which you can't afford because you're a startup or whatever the case may be. So it's really important that you have a tax accountant by your side.
And given that we have incubated some startups, and most do not have that capacity to actually buy, say, a channel, the frequencies, the FM, the AMs. Just curiously enough, when we go to YouTube, when they decide to actually broadcast through YouTube, are they going to pay a fee for broadcasting, or that's just strictly with the FMs and the AM?
Broadcasting is only tied to the FMs and TV stations and AMs. So the definition of broadcasting fits in literally in the traditional sense. When we start talking about the internet, we're talking about something else. Broadcasting, again, with the evolution of technology, the set-top boxes, the signet channels, those ones fall under broadcasting. So, but anything that deals with the internet it is another different conversation that predominantly features a lot in between media and intellectual property as opposed to business. But when it comes to being a broadcaster, of course, if you want to run a traditional media business, you'd be subject to some licenses. First of all, you have to take out a license with the Communications Authority. This will be dependent on the type of broadcasting business that you want to have, the kind of reach that you expect or you hope to have. So, of course, if you're going to be like a rural station, for example, even your statutory fees would be much less what you pay to CAK, or other Communications Authority, they rebranded, vis-a-vis what possibly a hopeful mainstream broadcaster would pay, for example. Again, these licenses are renewed like every year. With those licenses, which also again now touches into aspects of media law, we'd be talking about now the kind of obligations you have as a broadcaster in terms of the kind of content that you create and all these other things that we'll shortly talk about under media law.
Yeah, I think business registration is quite straightforward because I'm sure most, and even in school, it's kind of touched on during the curriculum. So we can move on to more murky waters when it comes to media law. And my first question is, are content creators classified as media practitioners in the law?
So not really at the moment. Media practitioners have been mostly narrowed down to journalists, the broadcasting houses, the editors, and the professionals that are found in a traditional media setup. Now, of course, the internet has been a game changer. We are creating content on our social media platforms. We have now the influencer culture that has caught up. We have bloggers who have caught on. And for a while, we had a conversation, or there was a conversation happening around whether bloggers should be part of the media. And of course, that has been a subject of contention because bloggers seem to enjoy a slight, they have sort of quote unquote given themselves more flexibility or power to speak their truth as opposed to a traditional media house, right? So again, there's been the conversation around if bloggers were to be regulated as media practitioners, then perhaps there might be some curtail of freedom of expression. So that is something that we've not really had a conversation around, or rather the law has now not yet prescribed, but there's that conversation. So the traditional media practitioners are those who are identified under the Media Council Act. So these are the guys who are not licensed, but I think they take out a license or a pass with the Media Council, and they're recognized as media practitioners. So those are considered the media practitioners. Everyone else, it will, it's a kind of situation depending on the type of content creator that you are. Of course, there will be some other obligations that will, follow you and you must comply with.
And maybe to give, I was about to ask what goes around within the media law, but I think it's best described with certain examples of issues that you've come through and how they've been solved. And then the bigger question is then how can you avoid, or how can you stay within the confinement of the law? So from your experience, if you can just take us through probably just one example that occurred under the umbrella of media law or for a media practitioner.
All right. So, for example, I just run a media business. I interview people on my blog or on my platform. I do, interviews, right? And so maybe I come to you and I ask you about your life story. And as you're giving me your life story, you start talking about either a best friend you had that you fell out with, and you share with me this, drama that you had with your friend. And then unfortunately, I just publish as is. I don't get details from your friend so that I can call them and sort of maybe give them a right of reply, because perhaps this conversation was maybe very, should I say, could be damaging to their reputation. For example, that it's something that would need their reply. So let's say, I was told that your friend stole your girlfriend or your wife to be or something at the altar, and then I'm quick to just go and publish it, right? And I even mentioned these people. Of course, I'm going to be liable for defamation, especially if it's not true. Yeah. So if you want to protect yourself from a defamation claim, for example, you want to make sure that you get the right of reply, or you give a right of reply from a concerned party, a party who's going to feature in your article. Defamation cases are some of the cases that, make media businesses go bankrupt, right? So the bigger broadcasters, bigger media businesses will survive because of the kind of monies that they generate. But imagine yourself as a small startup, already on a rough estimation, a defamation claim just in legal fees to open a file, we're talking about 100 and 150K. By the time the case is over, you've probably lost because you published false information. You're going to pay roughly 3 to 4 million in damages, and then you still have your legal fees to pay because you just paid a deposit. Yeah. I mean, of course, in between, of course, you've been paying for the lawyers to attend court. They are doing all these filings on your behalf. So already you can see the kind of minuses you're going through. And then imagine a situation where this other party, now they've won the case and they paid for what we call costs to their suit, which means now you're going to pay their lawyer. Imagine how much money that is already for a media startup. So it's very important that you fact check. Yeah. Something very common. Again, something with media businesses, when you're looking at the kind of trends you're observing in Kenya, is that with media, you have to also remember the right of privacy. That is another constitutional right that you must respect. So whichever subjects you're covering, the nature of the story, ask yourself, am I interfering with their right to privacy, or is it what we call quote unquote newsworthy information, right? Because it's a thin line sometimes. Yeah. So again, with that, if you do not do the right thing, you might find yourself in court for an infringement of right of privacy in court. Yeah. So again, it will really, at the end of the day, you have to be very careful with the kind of content that you're creating and how you're doing it. Are you doing it in the right way within the parameters of media law, of constitutional law? Sometimes you might even need to check with media lawyers just to confirm, what if I want to be a little bit outside the box? So what happens if I'm outside the box? Am I going to be okay? Or am I ready to bite bullets? Or I want to walk away from these potential bullets that might fly my way, right? So those are some of the examples I can mention that I have interacted with in my practice.
And for example, with the bloggers now and all these defamation suits, with the bloggers, they say, yes, I'm a sole proprietor. So if the suit comes, they will go for that person directly. Now, for example, in one of these large media houses, do they go for the journalist or do they go for the media house itself?
It will depend with the strategy at the end of the day. So chances are they will, as a plaintiff, I would probably attach the journalist and the media house together. Of course, there's what we call the deep pocket principle. I'll go after the media house because the media house is what will pay. And then the media house will check its employee and slap them in the wrist or suspend them or whatever the case may be, depending on the severity of the offense. But at the end of the day, of course, they would go for the one who's able to pay. And then the one who's paid will figure out how they will recover their costs, if either it's their employee or someone who was working on their behalf.
Okay, that's interesting. And I know we've touched about representation, but I know some will say, but that's a human. It's like, are there checks? I know you've spoken about going checking, is that there's the right of privacy, then there's the right of reply. But I know we've seen stories being published and then they have to be retracted and an apology issued. So other than those defamation suits, is there an opportunity for someone probably to reach to the media house and say, this is wrong? And then as the media house say, we'll offer an apology we'll publish an apology on the paper. Can that also be considered as a settlement agreement?
Most definitely. Under media law, apology is one of the greatest defenses that you can have, which means now myself as an aggrieved party, perhaps, there's some things that can be done that money will never solve or will never take back what happened, right? So, but maybe all I need is for the world to know that what so-and-so published is not true. So with an apology, for it to be effective, the same verb you used to publish that article, that same psych and chutzpah, that as they call it, or is it chutzpah, as they call it, right? It's the same way I want that apology delivered. So if it was on page 1 of whatever publication, that apology better be on page 1. If it was a quarter page or a half a page, the same thing, yeah? I think we really underutilize apologies because unfortunately, the media business is very egocentric, unfortunately. So you find that rarely do people want to eat humble pie and publish an apology and say, we apologize and da. So, and if they do, it will be like a small corner of the newspaper. And yet that article on the date it was published was either the first page or page 4 or, the first page of the business pages, So, when an apology is executed well, it will work. Again, with an apology, please don't go to the court of social media or what do we call it? The court of public opinion.
Yeah.
Yeah. So the thing is with apologies, you have to be very strategic about it as well. You have to be very, I don't want to say secretive, but respectful with how you get it. So then also it makes sense. Because again, with apology, when you look at the kind of stories that also may need apology, might be the kind of stories you don't want to keep repeated. So the minute you go on social media, now you'll create a digital footprint that regardless of an apology, people will always remember that this happened to Caleb. We so-and-so published X about Caleb, you don't want that to happen. So with apologies, you have to be very pragmatic, very level-headed. So again, at this point when it happens, please find a lawyer. And if you have friends who are already trying to, throw sticks and stones on Twitter, on Facebook on your behalf, you check them and tell them, you know what, I'm going to deal with this in the right channels. Please don't retract or delete any post that you have published immediately. And hopefully in your favor, nobody has already retweeted or taken a screenshot so that your strategy is more effective. Yeah.
Maybe before we exit this media law, I know we've seen a lot of investigative stories going around, and there's been that kind of backlash, especially for those who are implicated on those stories. I don't know how does the media law in this term protect this particular journalist?
So with investigative pieces, you have to be very aware of the rules around how you collect statements or information. So secret recordings, unfortunately, have been rendered inadmissible in Kenyan courts because as long as I'm taking a secret recording of you, it's going to be infringing on your right to privacy. So there is no way a wrongful act will gain legitimacy, even if it was around a very important topic. There will be maybe certain circumstances, but subject to the court's consideration, for example. Yeah. So at the end of the day, as an investigative journalist, you will still have to put it on record that, hi, Caleb. So my name is so-and-so. I'm from this media house. And I wanted to interview you about the murder case of so-and-so. We've heard that you've been implicated. Could you get to, do you care to give us a comment? You're on record. I'm recording you, right? I don't wait for you to speak everything. And then I tell you, oh, by the way, I was recording automatically. I can't even publish that stuff. Yeah. Because I'm going to find myself in trouble. So it's really important. Again, with investigative journalism, are you going to do a story around a minor? Do you know that you cannot show a minor's face? Do you know that you need to have spoken to their guardian before you interview them for your story? Things like that. It's very important that you're aware of. So with investigative pieces, you have to be more careful before you publish. There are a lot of, I's that you have to dot and T's that you must cross before you go to press or before you go to publish.
Maybe this is the last one on media law before we move on. There's this bit or at the end of investigative pieces or an article where the journalist writes, we tried reaching to Caleb for comment, but he did not probably get back to before the publishing of this article. Is that strong enough as a defense?
Again, it will be dependent on the circumstances. But what this, should I say, disclaimer or commentary that's granted there, it's basically just to show that there was an opportunity for right of reply and this particular person did not utilize it. But at the end of the day, it will be very dependent on the nature of story. To be honest, it's not a clear-cut answer.
So as Liz takes a sip of water, probably just for those who are joining us, this is the Conversations at the MIC, at the MIC, that's the Media Innovation Center. We are an acceleration and an incubation entity within the Aga Khan University that tries to help media startups build up and grow into fully functioning media houses. And today's conversation is all about the law. We are talking about business, media, and intellectual property law. And the idea of this is just to give guidance to these new media startups coming up and give them an idea on how to operate within the confinement of law, to know what is right and what is wrong, how they can protect themselves, and similarly, how they can protect the guys who they're doing the stories on. And at this juncture, we are going to move to one of the most interesting conversations that we've seen currently, even online, and it's all to do with intellectual property law. And I think this is really an interesting topic for me because I also kind of gauge myself as a content creator, and I've seen stories and I've seen people ranting and venting, saying, "Hey, why are people using my photos? They're using my videos to actually paint houses, to do, or rather to build their websites." And recently, we saw maybe an announcement from the governing body saying that photo courtesy of is not really is not giving credit. So probably you could just paint a picture because you've mentioned copyright, you've mentioned patent, but for media startup and also for content creators, what should they know when it comes to IP law?
So the general premise around intellectual property law is this: if it does not belong to you, you must find the owner and clear the rights. All right. So if I know I have not created this work from scratch, or I am picking something and using it, I must find the owner or the author and get their permission. Because it's the same thing with intellectual property, it's the same thing as, or the same concept as having a shamba, right? I don't just walk into your shamba and I start, picking your apples or taking your maize. Yeah. I have to come, knock, and find out, talk to the neighbors and say, oh, I've seen some nice maize in this plot. And it looks like the owner is not bothered. Who is the owner? Because I think I can take this maize and sell it and we can split profits or whatever the case may be, right? I cannot just walk into your house because you went on holiday and decide, oh, okay, I'm going to be like Goldilocks, drink your porridge, sleep in your bed, So the same thing with intellectual property. If it's not yours, you must clear the rights. So even when we're putting those disclaimers, oh, this music does not belong to me, or this content is courtesy of who? ? Right? Find the author. If you can't find the author, don't use it, because Specifically, as I said, in the media businesses, the greatest intellectual property aspect that is used is copyright law, which protects, like I said, the literary works, the artistic works, the photography, the audiovisual works, so the recordings, of course, as well, the sound recordings themselves, the musical works, depending on the different aspects, right? So you must, find the owner. With copyright, the exclusive rights that are granted are as follows. I have the exclusive right to reproduce my work, right? So I'm the one who decides if I'm going to have my work on Twitter, on SoundCloud, on Facebook. It is my right, right? So even just because I put it on Facebook does not mean that you have put it to the public. I only put it to Facebook on my account. So if you decided to take it and republish and just republish it or publish it elsewhere, you've reproduced it. You've interfered with my right to reproduce it. I have the exclusive right to distribute my work, right? So just because I've distributed it on Facebook does not mean you'll take it and go and put it on Twitter for me or on another page again, because that's again also distribution. Again, distribution may be viewed in different ways, but it's all about the reach, right? So that in the technology space, it would be about resharing. Also, it would be about the different platforms it might be available. And then there's a traditional mechanism where it would be on a CD and then I go and duplicate it, and share it everywhere else, right? But distribution is also an exclusive right. I have the exclusive right to control derivative works. By derivative works, I mean that you've interacted with my work, yeah? And then you decided that you're going to take a huge chunk of it, just change one or two things, and then, create, quote unquote, you think you created something new. Yet the consumers and my audience, when they see your work, they'll be like, but that feels like Liz's novel. Yeah. That's a problem. That's derivative works. You're going to be in trouble. You're going to, if you want to try and do a translation, I write a novel or a movie, then you try to translate it into Kikuyu, or in French, or in English, or whatever other language. That's a derivative work. You must, that's something that is my reserve. You have to come to me and I decide whether I'm going to give you that opportunity or that right to do so. And then, of course, you pay me. I have the right to make my work available. And I can decide tomorrow, I no longer want to make it available. It is my right as a copyright holder. Yeah. So I have the right to display it as well. I have the right to perform it, or put it in the public eye. Those are the exclusive rights that I have or a copyright holder has. So the minute you interfere with that and you've not requested for my permission or gotten a license from me, it's automatically copyright infringement. You are on the wrong side of the law. So when you're writing your story, for example, and you need a picture, make sure that you know the source of the picture. You're better off finding the owner of the picture. And if you find it on a website, for example, like these stock pictures, it's important you read the terms and conditions. Yeah. The different platforms will have different terms and conditions because even them, they know the kind of liability they can get. So you'll find some of them even cleverly will transfer that liability to you as the user and you didn't read the terms and conditions. So it's always very, very important that if it's not yours, you must clear the rights.
Speaking about translations, because you've talked about translating a whole article or a whole novel, there's this DJ that does the movies to Swahili. I can't remember his name. The famous DJ who does a lot of more of narrating a particular movie or an action series. Is that an infringement on the copyright from the producers and the directors of the movie?
So does he sell them, or is it like on a broadcasting station? What's the scenario?
I think so. The idea is he sits down and then probably watches this particular movie to the end, and then he narrates. But instead of doing it instead of like explaining what it's a really interesting way. I've forgotten his name. I don't know. I don't know if anyone remembers.
So here's the challenge. Like I said earlier, if it's not yours, you must clear the rights. That's what I always tell anyone who interacts with intellectual property in general. And I tell them, Kama si yako, then you must find the owner. If it's not yours, find the owner and ask them for permission. Then you discuss an arrangement over how you intend to use their work so that you don't interfere with their right to earn from this work. Yeah, because the minute you change the works, you interfere with their ability to further distribute their works or reproduce their work, you see automatically it's an infringement. Yeah. So you will not, you're not legally, you will not benefit from it. You find yourself in more trouble. So they'll have to recover all the profits that you made from that and then some. So it's always important that you get the permission, and then you can do as you will with the work as agreed by the author or the holder of the copyright.
Talking about complaints, so at what point do we register a complaint that this particular organization has actually stolen my IP? Because as you said, you can't take it to the court of public opinion where people come and run, say, oh, organization X took my photos without my approval or consent. Is there a particular place where people can actually register a complaint? And if so, what are the steps?
So with intellectual property complaints, they are personal. It's a personal right. Okay. So which means the primary nature of complaint would be of a civil nature. Yeah, because it's affecting my personal rights versus being a criminal issue. It would be criminal if it's on a wide scale. If it's, for example, if it's like say for example, the time when guys used to pirate signals, right? Then I have access to DSTV and I don't have a DSTV subscription. Yeah. Those guys would that would be a criminal, would bring both criminal and civil liability on the person who's doing that because of that kind of scale, the scale of their operation, right? So you find that the larger the scale, then you might also want to do the criminal aspect. But the quote unquote, for lack of a better word, the small sort of enterprises, you'll find that it will be a civil situation. Again, it will depend on the kind of stakes that are riding on the matter. The first thing you will do is when you realize that your work is being infringed on, please find an IP lawyer to help you, because the IP lawyer will be able to say, okay, so it happened online. Okay, maybe with online, maybe we can talk to them and figure out how you also earn and make some money on it instead of taking down the content, because they need to recognize you as an author. Maybe we'll need to tell, say, YouTube, this is an example. We need to tell YouTube that you've done wrong, but we are okay. We have reached a settlement agreement. Here is a settlement agreement. On the back end, they need to remember that 80% will go to your channel, for example, the kind of revenues that are being made on your channel, for example. So it will depend. It will entirely depend, but you need a lawyer to help you with that, because there will be some instances where you will need to take it down. Maybe the person will need to take down the content, and then even though you've taken down the content, it doesn't get rid of the fact that you have infringed on my work. So there I can decide, okay, boss, I want you to pay me X amount of money, or we go to court. Which one is it? So we start negotiating. Maybe we meet halfway and then we sign a settlement agreement. Because what will the settlement agreement help with? It will make sure now this issue doesn't come back to bite you, that you settled it full and final, and it will never come back or resurface again. So that's why you want to do. Then in the worst case scenario, you'll end up going to court, maybe because this party would not negotiate. You try to negotiate with them, you try to reason with them. All you wanted perhaps was some compensation, they refuse to give it to you, then you proceed to court. So again, the strategy of dispute resolution will vary with the kind of interests that are involved. But the standard position is do not go to the court of social or public opinion. Please seek legal counsel.
And normally in court, how long? Yes, the steps of now probably registering this complaint. I know you said get a lawyer, but would you just walk us through probably just the basic steps before you even go to session?
So if I was to comment on that, I might mislead. Litigation is a very intricate procedure. Yeah. It is about the civil procedure, using the civil procedure code. and the kind of documents that are filed. So just the preliminary, once I've seen a lawyer, they did a demand letter, they did comply, then there will be what we call a plaint. After a plaint, there will be a defense. In between, there might be documents, there might be amendments. It's a very complicated affair. It will be on a case-to-case scenario, circumstances to circumstances scenario kind of thing. So let me just put it this way. You want to make sure that you always are trying to be on the right side of the law, then your life would be much easier. By the time you're going to litigation, just know that you're going to be in court for between 1 and even 10 years. It will depend. Yeah. So unfortunately, it is what it is. And when you're dealing with other people, things become more complicated. Yeah. By the time we're going to litigation, it means one party did something wrong and they refuse to admit that they did something wrong. So we are now going to play this dance and, I don't know, flex egos. So it's a very intricate process when it comes to litigation. So I always say protective lawyering is better than defensive lawyering. So as a media business, protect yourself. You know, I know the basic argument or the general argument would be like, oh, I'm a startup, I don't have money. Think about seeking legal counsel as an investment in your business, not a liability. Don't think as money out of it as money out. Think of it as money in. Because if you have that preliminary legal advice, when you're starting your business, you will save yourself a whole lot of money. You see all these things we've talked about, from business law to media law to intellectual property.
Yeah.
You saved yourself. You know, in the beginning, at the business level, when you're reaching a business, you saved yourself from perhaps volunteering yourself for VAT because you don't make more than 5 million Kenya shillings in a year. Yeah. So you've saved yourself. Because if you didn't know that, what will happen? You've registered yourself for VAT and every month you must file your returns by the 20th. You've not done that. Month 1 passes, that's 20 G's fine. Month 2, 20 G's fine. Month 3, you realize by 6 months, that's what 20 G's times 6. And maybe for that fraction, you start with a lawyer, maybe even a quarter of that amount, you start with a lawyer, and at least they gave you the scope of what the things you need to think about and be aware of before you register a business. You see, you saved yourself money, right? So that's the thing. People need to realize that legal counsel is not a liability. It's not money out. It's actually money in at the beginning. Because by the time we're going to litigation, you remember when I was giving the example of the defamation case? Yeah. Just a lawyer opening a file for you, we're talking about 100,000 bob just to start the file. Yeah, just to say, Caleb, for me to start your file, I need 100K. And then, of course, we go through the whole procedure. By the time we're done, you might pay up 1 million Kenya shillings in legal fees, depending on the situation and how technical it gets and, you know, the kind of tricks that the other counsel might employ, right? Yeah, and then in between, somewhere you lose the case. Guess what? There's a judgment against you for like 4 million shillings. So already you're in debt, 4 million shillings. You have legal fees of maybe 800K. This guy gets lucky, the plaintiff gets lucky, and they are awarded also legal costs. So now we have to pay their lawyer. So maybe even them, their lawyer has charged them 800 G's. Are you seeing all that? Yeah. Yet if you had the lawyer from the beginning, you will have saved yourself all this financial drama. We're not even talking about the emotional drama. We're talking about just finance.
Yeah, that's a lot of money.
Exactly.
I think that's a good conclusive statement. I don't know if anyone has any question to ask, so you can just raise your hand. And as we wait, probably Liz, I know as broadcasting or news bulletins end, you know, at the end of at the end they usually have the logo and there are two symbols. There's the R within the circle and then there's the C within the circle. Could you guys just quickly differentiate between the two? Because I know one is copyright and the other one is a registered trademark.
Yes, so R is a registered trademark and C is the copyright, just asserting their copyright in the broadcast or in the recording. And of course, stating the year in which the recording was made. So copyright, you see the C circle 2021, 2022. You know, some of them even go to the extent of including even the month. So it's merely just to also assert their copyright, it's their footprint. So the minute you even maybe perhaps try to interfere with the recording and cut and think, oh, I'm going to be clever, I'm going to use this bit in my movie, automatically you're going to be in trouble because that's copyright infringement.
Okay. And with these shows, because I've seen a lot of shows, these talk shows, they are almost similar. And even these telenovelas, they literally have the same storyline. So you can even find the actors are different, but the storyline is the same. How can we classify that? Are we saying that you're stealing my idea, or there's a different element to it?
So I said earlier, copyright, intellectual property generally does not protect ideas, and copyright specifically does not protect ideas, but the expression of the ideas. The themes will be the same, the concepts will be the same. So copyright does not protect concepts or themes or business models, because those are very general things. That's part of, they're very raw in their nature, right? Those are things that we were probably exposed to because we went to school, we probably did the same curriculum. Of course, we know the same things, right? So it's about how I will do it. So how for example, Esmeralda, for those, I'm betraying my age here, but there was a popular soap called Esmeralda. And then I think at that time also we had The Usurper, the La Supadora or something like that.
Yes.
So those two, they kind of had like similar themes, right? There was a jealous boyfriend somewhere, a terrible mother-in-law, sijui what, all those smart things. But it's the expression. There was a reason we would watch Esmeralda maybe more than the other one, or we'd watch both because they made us feel differently, because it's literally about the expression. So we do not protect, you cannot claim copyright or intellectual property over a concept. Okay. Yeah. So when the minute you feel like you have something that could attract some proprietary rights, go see a lawyer, because what we will help you do is see how we can tweak this particular quote unquote concept into something that can be protected under copyright law. Yeah.
Thank you so much, Liz. I think you are so direct that nobody has a question, so we'll probably be just wrapping it up. Thank you so much for joining in. We will be hosting spaces at least once a month, and we'll be speaking on various topics that affect or that are really important to media startups within East Africa. So thank you so much. Give us a follow at AKU Media Futures, and keep you updated with many of the activities going on. We also have various training opportunities for media startups and journalists and also content creators that you can benefit from. So thank you so much, Liz. And thank you everyone for joining in.
Thanks for having me.